In any justice system, there's always that one big question looming. What happens if a court just gets it wrong? Well, under India's new criminal code, the BNSS, the answer is a crucial safety net, the right to appeal. So today, let's break down how this whole process works. I mean, seriously, what happens if you, or the victim, or even the state feels a court's decision just wasn't right? That is exactly where the appeal process kicks in. You can think of it as a formal way of getting a second opinion from a higher authority. Let's dive in.
So at its very heart, the whole idea of an appeal is about checks and balances. It basically means that if you're convinced a lower court made a serious mistake, you don't just have to live with it. You have the right to go and ask a higher court to take a fresh look. And this is a really key point. An appeal isn't a brand new trial. It's not like you're hitting the reset button and starting from scratch. No, it's a formal request for a higher court to review what already happened. The argument is simple. A mistake was made, either in law or in fact, and it needs to be fixed.
But here is the crucial catch, and you really need to get this. You can't appeal every single decision. The gate to an appeal isn't just wide open all the time. The law itself has to give you the key. In other words, the right to appeal has to be specifically granted by the law for your kind of case. It's a special right, not a universal one. And this ladder of justice you see here, it shows you exactly how that path works. A decision from a lower court, like a magistrate's, can be appealed to the Court of Session. From there, you might be able to climb to the High Court, and in some really important cases, all the way to the top, the Supreme Court. Each step up that ladder means a review by a more senior court. All right, let's talk about the scenario we all think of first. What happens when someone is convicted of a crime, but they're sitting there thinking, no way, I'm innocent, or this trial was completely unfair? Well, this is their right to challenge that conviction. This table lays it all out, nice and simple. The path is crystal clear. For example, if you're convicted by a high court in its original jurisdiction, your one and only appeal is to the Supreme Court. If a sessions court gives you a sentence of more than 7 years, your appeal goes to the High Court. And for pretty much any conviction from a magistrate's court, the next stop is the Court of Session. But, it's not just about the person who is accused. The BNSS really puts a spotlight on the victim's role in the justice system. So what happens when the victim is the one who feels that justice absolutely has not been served?
A victim can actually step in and appeal the decision, but only under these 3 very specific conditions you see here. First, if they believe the accused was just flat out wrongly acquitted. Second, if the sentence given feels way too light for the crime that was committed. And third, if the compensation the court ordered just doesn't cut it. This gives victims real power. And get this, it's not only the victim who can challenge a sentence that seems too light. The state itself can get involved. If the government, through its public prosecutor, believes the sentence is just too lenient and doesn't send the right message, it can file its own appeal to argue for a tougher penalty.
Okay, so like we said earlier, you can't just appeal everything. The law has these specific no appeal zones, and they exist for good reasons, partly to make the courts more efficient, and partly to respect the choices people make in their own cases. Let's see when a decision is really, truly final.
So here are the 2 big ones. First, if you plead guilty, it makes sense, right? If you admit to it, you can't then turn around and appeal the conviction itself. Now, you can still appeal the sentence if you think it's illegal or just way too harsh. The second situation is for very minor offenses, what the law calls petty cases. Here, appeals just aren't allowed. It's all about keeping the system from getting totally swamped with really minor stuff.
And just to give you a real-world number for what a petty case might look like, here it is. If a judicial magistrate first class hits you with a fine of just 100 rupees, and that's it, well, that's it. Case closed. There's no appeal from that. All right, so this is the final act. The appeal is in, everyone's made their case. So what happens now? What can the higher court, the appellate court, actually do? This is where the real power to change a case's destiny comes into play. So what can they do? Do they just give a thumbs up or a thumbs down? Oh no, it's way more than that. They have a whole range of powers that can completely change everything. The court basically has a whole toolkit. It can just dismiss the appeal, say, nope, nothing to see here. It can alter the finding or the sentence, maybe knock a few years off a prison term. It can go all the way and completely reverse the decision. Yep, turn a conviction right into an acquittal. And in some situations, it can just scrap the whole thing and order a brand new trial from square one. But with all that power comes a really important limit. Basically, the law puts a ceiling on what they can do. An appellate court can't just decide to give a harsher punishment than the original trial court was even allowed to give in the first place. This is a critical check to make sure the system stays fair. So you see, the right to appeal is this massive safeguard. It's a second chance, a check on power, a way to make sure one court's decision isn't the final, unchangeable word. But it makes you wonder, right? Is having this safety net, this path for review, enough to truly guarantee justice? Or is it just one very important piece of a much, much larger puzzle?